Let's see what you got.
For other purposes, we removed or whited out any exhibit that was not admitted in
Okay.
evidence. And then the only other whiteout was as to the Facebook records. The words anti-law enforcement sentiment were removed from the description. And I believe there's agreement of the state agrees those are as acceptable to be copied and sent back to the
Mr. Lenneman, any objections to this?
Objection.
All right, plus this one. All right, so we need to make a copy of this so that the original can go in the court file and the copy can go to the jury. We need one copy of that. That original goes in the court file as what was sent to the jury. And then the copy goes back to the jury. We have to have a record of what we sent them. And we have another note? Yes. All right, the jury wants a readback of the following: Captain Carter, Karen Livengood, and Markeith Loyd, all in reference to count 2. Madam Court Reporter, how long is it going to take you all to get that together? They want Captain Carter. I would say it would be his entire testimony because it says all in reference to count 2. So Captain Carter, Karen Livengood when she was testifying as to count 2, and Markeith Loyd when he testified as to count 2. So you would need directs and crosses on those things. And I'm going to need to pull the readback instruction. They're asking for. Does anybody remember when, how about the court reporter here, when Karen Livengood testified as to the scene of count 2, Captain Carter, the attempted murder of a law enforcement officer?
It would have been at the end of her first direct and at the end of her second direct. At the end of her first direct, my recollection is she testified about processing the scene in photographs.
Okay.
And then she briefly testified at the end of her second direct about collecting the spent casing.
Okay. So we'll have to look for that. I'm going to be reading to the jury 4.41. Members of the jury, you've asked the following testimony be read back to you. The court reporter will now read the testimony that you have requested, and I'll insert as each time. If you tell me what you're reading back, I'll just tell them this is the readback of Captain Carter and all that, okay? So how long do you think it'll be before you can do the readback? Absolutely, no problem.
Judge, can we approach for a second?
Sure. Well, this one's easy. They want tape and thumbtacks. There's the tape. Does anybody have thumbtacks? There may be some in my office. I'll check in a minute. All right. Let me go ahead and print this. All right, I'm going to bring the jury in. Let me talk to them about this readback and get more of a schedule with them. So let's get them lined up and bring them in, please. Yes, ma'am. Stay recognized, presence of the jury.
We do, Your Honor.
Defense? All right. I brought you into the courtroom just to talk to you a little bit about the readback testimony. So you all are asking to have read back. This is how I understand the note. You want us to read back Captain Carter's testimony in its entirety about count 2. Karen Livengood's testimony about count 2, and Markeith Loyd's testimony about count 2. Have I got that right? Okay. And by testimony, we mean direct and cross-examination. All right. I've talked to the court reporter. In order to get this assembled, It's going to take us until tomorrow morning to get it done. We're happy to read it back to you. Please don't take this as us not wanting to read this back. It's going to take until tomorrow morning because the testimony is spread out through the transcript and has to be looked at. We need to make sure we're reading all of it to you. You can continue to work on what you're working on now. I do want to tell you all that I know it's been a very long day for you, all right? You can continue deliberating. We want you to deliberate and be comfortable, but as soon as you all start to get tired, you need to let me know and I'll send you back to the hotel, all right? So are we good with this plan that we will read this back to you tomorrow morning? Yes, ma'am. If you all want to talk about it and send me a note about it, do that, okay? So let me know if that's fine or if you have any modifications or questions about this. That's what took me so long to answer you, is we had to figure out where it all was. All right, so why don't you head back to the jury room and let me know if you have anything. All right. Yes, sir.
Because we discussed it briefly at the bench on the issue of a partial readback, I would just cite the court and defense counsel to Avila, A-V-I-L-A, versus State, 781 Southern 2nd, 413, Florida 4th, DCA 2001. It indicates the trial court may provide a limited or partial readback of testimony specifically requested by the jury as long as the testimony is not misleading. That was a head note.
All right, thank you, Mr. Williams. All right, so if they're still requesting the readback, it's incumbent on the lawyers. You're going to need to pull up your real-time transcripts and make sure that there's not something else that you want to read that's specific to the request they made. I'm not, they want Carter, Livengood, and Mr. Loyd. That's it. You don't have to do it tonight. You have to do it before we do the readback.
Judge,
Yes, sir.
as to the issue of the misleading nature of the testimony, in this particular case, there was another witness who testified to results from that investigation, and that would be Richard Booth. As you recall, Judge, there were 3 projectiles and 1 casing found.
You can't add witnesses to the requested readback by the jury unless that witness materially alters something. So you're going to have to pull the testimony that you say is relevant and let us all see it.
Okay.
I can't address it without looking at it. I can't just start reading off witnesses to them. Okay.
Understood.
Thanks. Okay. Let's see. Okay, so wait, I have another note. All right, this is what I'm getting back from the jury. Monica Pridgeon, count 1, Sergeant Pete Caddis, count 1, Shane Overfield, count 1, Karen Livengood, count 1, Markeith Loyd, count 1, Julia Johnson, count 1, and Dr. Joshua Stephanie. We'd like to retire at 7 p.m. and resume when we have these testimonies in order to come to a verdict, unless we're able to get them sooner. It's 20 minutes to go, so I'll give you all a moment to absorb this. And discuss it among yourselves. Monica Pridgeon, Sergeant Pete Caddis, I'm just reading what they wrote, Shane Overfield, Karen Livengood, Markeith Loyd, Julia Johnson, Dr. Joshua Stephanie. Sure. Y'all let me know when you're ready to address this. State, you ready?
We are, Your Honor.
All right, what's your position on this?
Our position in order of witnesses is that it would have to be all of the direct and cross-examination of Ms. Pridgeon, all of the direct and cross-examination of Detective Overfield, all of Ms. Johnson's testimony, direct and cross,
Correct.
all of Dr. Stephanie's testimony, direct and cross. The three that are a little more complicated are Detectives Cadis, CST Livengood, and the defendant. I mean, we're getting into an area where what does related to mean? There's an argument that almost all of their testimonies would be related to count one. I guess we're sort of looking for guidance on those, but the ones I announced to the court, we agree they have to all be read based upon the request from the jury.
All right. So you're saying the issue you have is with Mr. Loyd and what part of his testimony would relate?
Yes, Your Honor.
Okay. And just determining what part of that testimony is related to count one?
Yes, Your Honor.
Okay.
Same with Sergeant Cadis or Detective Cadis.
All right.
And then the same thing with Ms. Livengood.
Yep. All right. Mr. Lenneman?
Yeah, I'm in agreement mostly with what Mr. Williams says. I think the issue about the perimeters of Mr. Loyd is that we have both the heat of passion and the insanity defense and the self-defense all in his testimony. And there are some aspects of the insanity defense that are not present when he talks about specifically Walmart, the state of mind and so forth, the events that occurred with the press, and him believing the police are going to kill him. As in terms of Detective Cadiz, again, I don't have that in front of me, but I think what's relevant here is that the defense has said there has been a conflict in the investigation. He's involved with making statements to Mr. Loyd. He's involved with the casing or the projectile that was found by Detective Overfield. And so I don't know what else the perimeters of his testimony is, but we hear differently from the jury, I think we have to read all of it back.
I'm not in agreement that we have to read all of Mr. Loyd's testimony back, because all of the stuff about Sade Dixon and all that.
I agree with you on that,
not
Judge.
Part of, so I can tell you right now, I'm not reading the whole thing back.
I agree with you. I think a starting place may be when he talks about the news.
I think what I'm going to do is read the jury this instruction on this one, which is, again, it's 4.4, but it's paragraph 2. I mean, I don't have to read back testimony. It's in the discretion of the court. I'm inclined to read back testimony when asked.
Yes,
but
ma'am.
This is a major chunk of the trial. We would spend about 8 hours reading back testimony with this. So, members of the jury, I've discussed with the attorneys your request to have certain testimony read back to you. It will take approximately, I'm going to guess, based on how long all these folks were on the stand, that we're talking 4 or 5 hours of reading here. So that's what I'm going to tell them. To have the court reporter prepare and read back the requested testimony. I now direct you to return to the jury room and discuss your request further. If you are not able to resolve your question about the requested testimony by relying on your collective memory, then you should write down as specific a description as possible of the part of the witness's testimony that you want to hear again. Make your request for reading back testimony as specific as possible. Because this is in essence an entire day of reading back.
I understand, Judge,
Which
but
is-
my position is, I understand about Mr. Loyd's testimony being narrowed down to the precise issues, and I think we can do that. But I think Ms. Pridgeon, and I'm in agreement with Mr. Williams on that, Ms. Pridgeon and Julia Johnson have to be read in whole. Overfield's testimony is pretty short. I don't know what they're looking for, but...
I don't disagree with you.
Right.
I can't, though, start nitpicking which one of these I want them to be specific about, because then it looks like I'm reluctant to read a certain person's testimony back.
Well, this is my position, Judge. I do not want a reference to me as an attorney, as one of the attorneys have talked about this, because I think that infers that I'm in part of putting pressure on them to narrow their decision and get on with their verdict, and that's not what I want to do. I don't have a problem with the rest of your statement that says, you know, it's going to take 4 hours, go talk about it. I don't have a problem with that. I just don't want to be part of the lead-in.
That's a standard jury instruction. It says the attorneys. I can insert the word all of the attorneys. But, I mean, this is the standard jury instruction. I can tell you that I've been involved in more readbacks than I care to be involved in. And if you have to be careful in reading these instructions to not, you have to read the instruction. State.
We don't object to Your Honor's proposed reading of the instruction. I would just ask the court to put the number of the instruction on the record.
It's 4.4, paragraph 2.
Thank you, Your Honor. But we don't have an objection to the court's proposal.
Yeah, I did. I thought I put that on the record. Can you all not hear me? That's why I'm asking.
You may have, and I missed it, Judge. I'm sorry.
Yeah, it's okay. I just want to make sure you could hear me. So let me take the mask off. What? Can they eat dinner at the, well, yeah, we need to get going because they need to eat dinner. So I need them to narrow this down. This is just way too much readback. And I suspect they're looking for specific issues. So I'm going to bring them in here and read this instruction to them and send them back in there and tell them that we are going to send them home, or home. We're going to send them to the hotel at 7 o'clock. So let's get them in here.
Judge, just for the record, I understand that that's a standard. I just object to the all attorneys.
Well, I'm just going to read it the way it is. I've discussed with the attorneys your request to have certain testimony. I don't think that singles you out it says the attorneys. I have two here and two, well, one over here. Mr. Marrero has disappeared. So, all right, let's bring the jury back in.
So
here,
actually,
sir.
just so we're clear, I'm objecting to the.
I've got it. You object to me reading the word attorneys.
No, I'm actually objecting now to this being read.
Okay, I've got
Okay,
it.
Thank you.
State recognized presence of the jury.
Yes, Your Honor.
Defense?
Yes.
All right, good evening, folks. So I've got your list of all the witnesses. I take it this is in addition to Captain Carter and the others. All right. So I have an instruction to read to you all. And I know you want to go home soon. Just going to need to read this, send you back to the jury room for a minute, and then we'll send you back to the hotel because it is almost 7 o'clock. Members of the jury, I have discussed with the attorneys your request to have certain testimony read back to you. It will take approximately, between both requests, somewhere between 4 to 6 hours to prepare and read back the requested testimony. I'm now going to direct you to return to the jury room and discuss your request further. If you are not able to resolve your question about the requested testimony by relying on your collective memory, then you should write down as specific a description as possible of the part of the witness's testimony that you want to hear again. Make your request for reading back testimony as specific as possible. So if there's some specific issue you're focusing on, that kind of thing, let us know as specifically as possible, because this is 4 to 6 hours of reading. Okay? So last time I'm sending you back to the jury room. Send me one more note. All right, thanks.